Hi, everyone. Welcome to Chalk and Gavel. Before we get into the episode, I want to remind everyone to like, rate, review Chalk and Gavel wherever you get your podcasts. You can also check out our wonderful merchandise on chalkandgavel.com. Maybe you need a dad hat that says Chalk and Gavel. We don't have thigh or calf high socks with Chalk and Gavel's logo on that. Maybe we need to do that. Maybe some New Balances.
We have a brand.
Cargo shorts. I think we do.
We gotta keep the image.
But yeah, we got the dad hat. We've got the coffee mug, which I'm very excited about. The Don't Do Nothing mouse pad.
Yeah.
The document journal.
Lots of Chalk and Gavel. The throw blanket.
That's right. The flamethrower.
Flamethrower.
Wait, what?
The kids love this one. Can I just say I am so excited for that new Spaceballs movie that's coming out next year.
They're making another one?
Where have you been, dude?
Not in 1994.
Wow. No, it was 87, but that's okay.
Okay.
They've been talking about it for... Oh, boy. I remember when it came out. One of the finest films ever made.
I will not disagree with that.
Ever. And I mean, oh man. Yeah, no, they're making a new one. Mel Brooks, very involved. He reprises his role.
Really?
Bill Pullman, Rick Moranis is coming out of his 30-year retirement.
I was going to say he hasn't been in anything in ages.
Mm-hmm.
Okay.
Yeah, He retired back in the 90s, and he's back, baby. Daphne Zuniga.
Okay.
And Josh Gad wrote it, I think.
Really?
Yeah.
Olaf? Okay.
Olaf, yeah.
Yeah, I'm into it.
Yeah, I am so thrilled about this. So, there's your movie reference for this episode.
Welcome to Schwartz and Helmet, the review podcast of Spaceballs and Spaceballs 2.
Oh, man.
But anyway, Jamie, should we get into it?
We probably
Not Spaceballs, the case we're covering today.
Now I'm going to have to go watch the movie tonight. We could. But anyway, go to our website, check out our merch, support the show, do all that fun stuff. And let's dive into today's episode. What you got?
So, can a school, consistent with the Fourth Amendment's prohibition on unreasonable searches and seizures, randomly drug test student athletes?
Yes, they can. Thank you for tuning in. See you again in 2 weeks. We're done. No,
we talked about Spaceballs longer than we talked about
I know.
this case.
Yeah. There's your answer. Yes, they can drug test student athletes. But if you want to stick around a little while longer, we'll actually tell you why. Yeah, so we've covered other student search cases on the show, but those were all based on individualized suspicion where particular students were suspected of wrongdoing. Today, though, we're diving into another Supreme Court search case, Vernonia School District versus Acton. But this one is about searching a whole bunch of people when no individualized wrongdoing is suspected.
Right.
Ooh, the plot thickens. So that's what we're going to do today. Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Jamie Cudlitz. I'm a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and school attorney. Now we're both professors of educational leadership, telling the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
The kids are alright. The kids are alright. The kids are alright.
All right. Jamie, do you have a bell ringer?
I do. All of this is, when we're searching for bell ringers, this stuff is now like low-hanging fruit. So here we go.
It's one thing after another.
It is. So we've spent a lot of time talking about the Trump administration's efforts to dismantle the Department of Education. which has in many ways over the last year involved offloading its responsibilities to other agencies, gutting staff, and trying to narrow the role of federal government, or at least narrow the role that the government plays in education. Although, interestingly, just offloading DOE responsibilities to other federal agencies doesn't quite meet that particular objective because it's all still in the federal government, right?
Right.
It
Technically, the federal government is still doing the same amount of work with the same statutory obligations.
Exactly. So what it's really doing is it's just putting a lot of people who likely don't have much expertise in education in charge of lots of education things. But
right.
Whatever, I digress. So the latest in this ongoing saga is that the Department of Education has announced that it will be shutting down the OELA. Everybody knows what the OELA is, right?
Oh, of course.
Yeah. So the OELA, that is the Office of English Language Acquisition.
Oh, okay.
Yeah. So English language learners and multilingual learners, those, a lot of those initiatives and those
right.
Title III funding and grants and stuff like that for multilingual education support all goes through OELA. So anyway, the bellringer is that that's the next Department of Education office that is on the chopping block, with its responsibilities being offloaded to other agencies. Again, like other shuttered departments and programs, the funding streams and the statutory responsibilities will remain.
Right.
That's what they're saying.
Yeah.
And they kind of have to, right?
Right, because Congress hasn't changed those laws. Right. And, this is a similar pattern, right? We've seen this where the Trump administration announces an office closure. They say they're going to offload the responsibilities. There's probably going to be a lawsuit, either by the employees who no longer have positions or from other stakeholders saying, hey, you can't do that, or hey, you didn't do the right process to do what it is you're trying to do. So, we'll have to watch those lawsuits. And I think there's a bunch of those working their way through the system right now, even going back to like our first bell ringer on, the what did we call it? The hallway of education.
Oh, where, the FedEx or the UPS of education.
Exactly, right. And all of that's still being challenged, and we're still waiting to see what the courts do with all of that.
Yeah. Yeah. And in the meantime, I think it's important to reinforce that, especially given that this is just a steady stream at this point of the same thing, right? And we've talked about it a lot before. The important thing to remember is this. Just saying that the money is still there and so are the responsibilities, that's not likely enough, right? Because it doesn't capture the practical realities that could have long-term impacts. And so here's what I mean. Lots of government agencies are understaffed, right? So handing over new programs and responsibilities to these understaffed agencies means that they could obviously run into some roadblocks. Plus, the people in these other agencies, like I said, aren't usually education experts or career education people. So all of this results in a cutting off of education expertise and oversight, right?
Right. Yeah, you're losing a ton of institutional knowledge as well.
Yeah.
Because you could have to reinvent the wheel.
Yeah,
and that's going to have disruption.
Exactly. And, and other things, the other thing is that folding these programs into other more generic non-education agencies means that the voices that those programs were designed to serve are going to have a harder time being heard, right?
Right. You're just one amongst many now.
Exactly. Before, in an office that was solely responsible for English language acquisition, those folks not only had a seat at the table, but the table was set specifically for them, right?
Yeah.
And now it's much harder to find a seat at a table that isn't even set for them. So
much more crowded, much more variable.
Yeah, exactly. So, there's your depressing news for the day. Have a good one, everybody.
You're trying to end this episode a lot of different times. Let's talk about the case.
Oh, yeah. Okay. Let's talk about the case. All right. Okay. So let's get into the Vernonia versus Acton case. This was from the mid-90s, okay? So as we mentioned at the top of the episode, we're going back to explore this foundational case in education law. The case is all about how far schools can go to protect student well-being in the face of students' privacy rights, okay? How do we balance those two things? On one hand, we've got a school trying to protect students from the harms of illegal drug use. And on the other hand, we've got students who would rather not pee in a cup and subject themselves to the embarrassment and intrusion of these random drug tests.
Right.
But I will say, like, nobody was asking them to stand in like a line out in public, and
right. The how of collecting the sample is actually an important part of this case.
It's
but
important.
That tension between liberty and protection,
Safety,
that's something that schools have to grapple with all the time.
All the time.
That's kind of a perennial issue in students' rights cases.
It's perennial issue in society, right?
That's
in
true.
Government. How do we balance rights against the need, the greater good, and all
What's
that
that
stuff?
line? And I forget who said it, but those who would give up liberty for safety get neither. I forget who said that.
Oh,
But there's always been that tension. I think it was one of the founding fathers, but it's always been that tension of if we give up our freedoms, if we give up liberty in the name of safety, then we're jeopardizing both essentially, but they're always kind of at odds, or there's a potential conflict between those two ideas.
Yeah, exactly. Okay, so the case begins in Vernonia, Oregon in the late 1980s. So that was right around when Chris was born and I was probably in middle school.
And when Spaceballs came out. Spaceballs 1, excuse me.
Yeah. They decided to call the new Spaceballs. Spaceballs, the new one.
Oh. They're good at the on the nose stuff.
I know. It did not end up becoming Spaceballs, the search for more money.
That was the joke.
That was the joke, yeah. But according to Mel Brooks, he said he had the money all along. It was in his basement.
Oh, good.
Okay. Anyway, so
also happening in the 1980s
was this war on drugs, right? And so if any of you were around back then, like I was, like Chris was not, or at least couldn't remember any of this.
No.
I vividly remember Nancy Reagan's war on drugs. I remember those commercials, right? Oh man, these commercials were, this is your brain on drugs.
Yeah,
Did you ever see those?
Too. Yeah. Just say no,
just say no
to drugs stuff. Yeah.
Yeah. So that was a big, Nancy Reagan was led up that effort. But that was pretty big back in the 80s. So there was also Congress had enacted some harsh anti-drug laws in the 80s. It was a hot topic, right?
Right. Yeah. I think that was kind of the height of it.
Yeah.
The 80s and 90s.
Yeah, exactly. So what does this have to do with Vernonia, Oregon? Well, the Vernonia School District's sole high school was also experiencing the harms of student drug use. Despite being described as small-town America, drugs were seen as a major problem in Vernonia schools. Teachers and administrators had observed a sharp increase in drug use in the late 1980s, and this led to tension between students and administrators as students began to kind of flaunt their drug use and boasted that there was nothing the school could do about it. I'm stoned and you can't do anything about it. Back off, the man.
Right. That's exactly what I'm thinking. This entire case makes me think of the movie Dazed and Confused.
Oh, yeah.
Right? Speaking of throwbacks, right? But this whole idea of this rebellious student drug culture versus the man trying to it's like Breakfast Club meets Dazed and Confused.
I know,
right?
But wait, it gets better, man. I'll read you something in a second. But between 88 and 89, the number of disciplinary referrals in Vernonia schools rose to more than twice the number reported in the early 1980s. Okay. And several students were suspended.
Sure.
became increasingly rude during class. Outbursts of profane language became common. Things were not going well, according to school officials. Dogs and cats living together, mass hysteria.
Good, we hit our Ghostbusters quota.
You know what? If we can do it in every episode. And it's always the same quote from that.
Right. Yeah. We gotta go rewatch that
some
one.
new ones.
Yeah.
So at the high school, school leaders saw student athletes as the leaders of this drug culture.
Okay.
That interesting. This was a particular concern for two reasons, according to the administrators at least. First, student athletes were admired within the school community and seen as influential figures.
Sure,
Okay?
yeah. Role
That makes
models.
sense. Yep.
Yeah.
That makes sense. Second,
Star of the football team.
Yep, exactly.
Mhm.
Second, they had thought that illegal drug use would increase the risk of sports-related injury. That seems like a, I don't know what drugs they were,
Right.
dealing with. I mean, like, my guess, if it's the 80s, I'm guessing marijuana and cocaine potentially.
Right.
I don't know.
But yeah, you got to imagine that, like, hey, maybe it's not the best for athletic performance and whatever for students to be stoned while trying to play sports.
Listen, I'm wondering, like, if they were really that stoned, wouldn't they just be sitting on the bench eating chips?
They're probably
Nah, man, you go play. I'm cool right here.
It depends on what drugs they were doing, I guess.
Exactly. Okay, so listen. Later at the trial, the school would offer expert testimony.
Okay,
on the
so
negative,
experts, not just you and I.
Yeah, exactly.
Good.
We're not. So they offered expert testimony of the negative effects of drugs on motivation, on memory, on judgment, on reaction, on coordination, performance, all that stuff. So they offered expert testimony. And the high school football and wrestling coach reported witnessing a severe sternum injury suffered by a wrestler and various omissions of safety procedures and misexecutions by football players, all attributable, at least in the coach's belief, to the effects of drug use.
Okay. So we've got these expert witnesses. We've got some personal experiences from school personnel about, like, hey, I think this happened because students were on drugs.
Yeah.
So we're starting to build a picture here.
Yeah, exactly. And it sounds like from the description in the, in the court record and everything is that this was some intense stuff going on. They had their hands full with lots and lots of drug use. So what did the school do about it, you ask?
I think I know one thing they did.
Well, yeah, they drug tested. But before that, their first step was to offer special classes, speakers, and presentations about the harms and dangers of drug use. I'm not sure if Nancy Reagan showed up or not.
An educational campaign, very appropriate for a school.
I remember various things in, by the time I got to middle school.
Oh, yeah. Like
we had speakers and things
Dare?
like that. Dare. Yeah.
With like simulated drunk driving car accidents. I remember vividly standing outside in a parking lot with like actors acting out
interesting
traffic collision involving a drunk driver. Yeah.
Oh, wow. Oh,
it was intense.
Yeah, it was. Yeah. Like there was a lot of traumatic experiences designed to keep us away from traumatic experiences.
Wait a second.
So anyway, I don't think that those programs, or at least the school didn't think that the programs had the effect that they were hoping for. So they decided to take it to the next level. They brought in drug sniffing dogs. That didn't work. So they kept going, I guess. And here's why. You're going to like this. I know, Chris, that you're usually the one who deals with the court's opinions. But I really want to read this passage because I think it really shows where things stood, or at least where the school and the court, trial court at least, thought that things stood. Because this is fascinating.
Yeah.
Here's what the trial court said. I'm quoting. The administration was at its wit's end, and a large segment of the student body, particularly those involved in interscholastic athletics, it's very hard to say, was in a state of rebellion.
State of rebellion?
Now we've got Star Wars.
Okay,
Rebel
yeah.
scum. Disciplinary, I'm continuing the quote here.
Yeah.
Disciplinary actions had reached epidemic proportions. Okay.
Wow.
The coincidence of an almost threefold increase in classroom disruptions and disciplinary reports, along with the staff's direct observations of students using drugs or glamorizing drug and alcohol use, led the administration to the inescapable conclusion that rebellion was being fueled by alcohol and drug abuse, as well as the students' misperceptions about the drug culture.
Wow.
Unquote.
There's so much to unpack from that quote.
It sounds apocalyptic.
Right. It does, like,
doesn't it?
Rebellion, epidemic, like there's just some very loaded words. And also, like, it sounds like staff are watching kids do drugs at school.
I mean, that's the crazy thing. Like, on one hand, you hear that and you're like, what was like
what was it like to actually be at this school, right? Because
Yeah.
like, this is all secondhand, but like this is also from a court decision, and the court collects evidence, so you got to assume that like the school put on evidence to support this. And I think like that threefold increase in classroom disruptions, like it sounds like they had the receipts.
Yeah. I mean, we also know that.
I don't think it probably was a rebellion, because I don't think the students were seizing, the means of control over the school. They just weren't doing what the teachers wanted them to do. And I don't know if that's what I would call rebellion.
It sounded like it was a complete mess, whether the mess was perceived and sort of really blown out of proportion, or if it, was based in sort of like, honestly, teachers watching students do drugs.
Right.
That's
I mean, that like, yeah, if they're like, if students care so little for adult authority or the rules that like, they're just completely
sitting in class
disregarding
doing
it.
Yeah.
Oh my gosh. But like at that point, the school has options, right?
I'll answer all the questions, Mr. Smith.
But the school has options though. Like if so that's like the big tension in this case, right? Is like, if you suspect specific students of doing drugs, you have a whole bunch of stuff you can do.
Yes.
Right.
But it sounds
that
like
doesn't mean that you then drug test everyone to find the people who are doing drugs. Because like, if they knew it was such a big problem, then they had to have known who it was that was responsible for this. Like, I mean, it sounds like the issue of like the drug culture is a big motivating force here, where like it just was so pervasive that even if they
even if they did try to target individuals that they suspected, they wouldn't capture anywhere near what they needed to in order to mitigate whatever was going on from a larger cultural kind of standpoint, right?
Yeah.
So at that point, the school began considering drug testing programs. Okay. So school leaders held a parent input night to discuss a proposed plan to randomly drug test student athletes.
Okay.
So parents were apparently completely and unanimously on board with this approach. They were like, bring it on, folks.
So they're experiencing the same sort of open rebellion as well.
That we're speculating, but that
I guess.
all signs point to that, right?
Right. And kudos for the school leaders to,
bring the parents in,
start to do the community engagement before, like,
because
hey,
it's
here's
a community
the problem,
right?
Right.
Yeah. And this is where schools can, schools are community hubs, right?
Mm-hmm.
So anyway, that sounds great. In the fall of 1989, the board approved the student-athlete drug policy. And here's what the policy said. It said, in order to play sports, students and their parents had to sign a form consenting to drug testing. Athletes were to be tested at the beginning of the season and once a week during the season. All right. 10% of athletes would be randomly chosen for testing as well. So they weren't going to test everybody. They were just going to randomly select 10% of the athletes.
Right. And so everyone gets tested at the beginning, and then during the season,
Weekly.
you're in a lottery, and maybe you get chosen weekly. Okay.
Yeah. And so here's what the testing consisted of. Going into the locker room with an adult monitor of the same sex. Boys would produce their sample at the urinal, meaning they were fully clothed with their back to the monitor, to the person who was monitoring, right?
Sure.
Not the computer monitor. This was also
that's a different can of worms.
Yeah. We had computer monitors, but they were very big and clunky and probably not in the locker rooms. So anyway, they're fully clothed. The person is watching them, but their back is the person giving the sample is at the urinal.
Yeah.
Back is to the person monitoring.
Okay.
Girls would go into the stall and close the door. The monitor would stand outside and could hear what was going on, but not visually observe.
So yeah, they're not looking at your unclothed body, but it's not business as usual because you've got an adult in there with you instead of just other students.
Right.
And you've got an adult in there with you whose entire attention is focused on the noises you're making in the bathroom.
Right.
Like, that feels super icky.
Well,
and that's my technical term.
No, and I would categorize it as icky and not super icky. I think if somebody was standing there looking at your unclothed body, that would be super icky.
Yeah. They can both be super icky.
Oh, they can, but I think that there's a ickiness spectrum.
Maybe the medical nature of it makes it less icky, right? Like they're listening for a very particular purpose.
Yeah. It's the stuff you do in the doctor's office and whatever.
Yeah.
Right? But even, no, listen, I'm with you. I'm not arguing that
you're just arguing
there's
about
no
there. The degrees of icky.
Yeah. I think, the degrees. Let's write a paper on that. Okay.
But that's going to come up in the court's opinion, right? How they use the word intrusive is this. They don't talk about the ickiness factor.
Yeah. Okay. So once all that sampling was done, the samples were anonymized. All right. Okay. And they would be sent to an independent lab, which reported a 99.94% accuracy rate for detecting amphetamines, cocaine, and marijuana.
Okay, well, that answers your earlier question.
There you go.
That's a pretty good accuracy rate.
Or at least that's what they thought were the biggest problems.
Right, okay.
They could also test for LSD, but that wasn't part of a typical screening process unless the district asked, and I don't think the district asked. So, if you were...
This probably wasn't cheap for the district. I'm thinking about the administrative cost of this. This is probably not an inexpensive program.
No, I'm thinking, I wonder how public what they were testing for was. I wonder if the students knew, well, they're not testing for acid, so...
Right, let's go do shrooms. Let's go do that. That's not being tested.
Right? The results of the testing, those were shared with the superintendent, the principals, the vice principals, and the athletic directors. No one else had access to the results. No teachers, no parents. It was just those school officials I mentioned. Okay. And now,
the coaches could probably figure it out.
Yeah.
If the kiddo's not on the team anymore, right? But
Okay.
Right. Yeah.
Okay. So here's what would happen if a kid failed the test. A second test would be administered to confirm the result.
Okay. For those 0.06% of false positives.
Right. Exactly. So if the second test was also positive, meaning that they failed the test,
that they found drug use. Yeah.
The students' parents were notified. A meeting was held between the student, their parents, and the school, and the student was given two options: either a 6-week drug assistance program with weekly testing, or a suspension from athletics for the remainder of the current season and the next athletic season. Okay. A second offense automatically resulted in option number 2. So you're done.
Right.
All right. A third offense resulted in a suspension for the current season and the next 2 athletic seasons.
Okay. So we've got progressive discipline.
Yep.
You're out for at least a full season.
Yep.
Plus the remainder of whatever the current one is.
Yep.
Or you can do this kind of 6-week deferral program.
Right.
Okay.
Which would allow you to keep playing, but if you're going to keep playing, you're going to potentially be
weekly tests.
Yeah. Exactly. So
okay.
That's the whole system. Fast forward to the fall of 1991, and we've got James Acton, who is a 7th grader, and he signed up to play football. However, he was denied participation when he and his parents decided that they would refuse to sign the testing consent forms. And given that this case is called Vernonia School District versus Acton, Chris, what happened?
They made a movie about it and they called it Dazed and Confused with Matthew McConaughey. No, they filed a lawsuit against the district. So Acton is claiming that the student athlete drug testing policy violated the Fourth Amendment. And his case ultimately got all the way up to the Supreme Court of the United States. The trial court had initially held for the school and dismissed the case, but the Ninth Circuit Court of Appeals reversed that and held for the student, saying that, yes, the drug testing policy did violate the Fourth Amendment's prohibition on unreasonable searches and seizures.
Interesting.
So, 1 for 1, we're up to the Supreme Court. What does the Supreme Court do? So, as is appropriate, the Supreme Court started with the text of the Fourth Amendment. I think we've talked about the Fourth Amendment a bunch, but it says that the government shall not, quote, violate the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And that word unreasonable is so important because that's what this entire case hinges on is how do we decide what is reasonable or unreasonable for a particular search.
And that's a word that a lot of cases hinge on, right?
Right.
Not
the
just
law
search
loves
cases.
that idea of reasonableness.
Yeah.
It is everywhere in the law. And it is such a squishy term.
It is. And it's so funny too, because so many folks, including most of our students, right, who come into an education law class, have this perception like, I'm going to learn what's right and what's wrong. I'm like, no. You're going to end up really because you're going to see this term, what's reasonable, so often.
Right. And it's not like, it's an objective term, meaning that like, what would an objectively reasonable person do? So it's not even like a real person. It's this made up idea that we have in our heads for like, just the ordinary person who is reasonable.
Right.
Anyway, it's a construct of the law. It's everywhere.
Right.
We just have to deal with it.
Right.
And, as Jamie kind of alluded to at the top, we've talked about other student search cases on the show. So we covered New Jersey versus TLO, which was the smoking in the girls' room case. That was all the way back in episode 15. So that was a minute ago. But that case dealt with when school personnel can search students based on individualized suspicion, meaning they suspect a particular student of wrongdoing and they think the search is going to turn up evidence because of that suspicion. But the search here, the drug test, every single student athlete is getting drug tested. So there's no individualized suspicion. It's a blanket search.
Right.
Sometimes you'll hear it called a sweep search or a suspicionless search.
Yes.
It applies to everyone.
Right.
And so because of that, the TLO standard doesn't apply. We need to figure out in this context what is reasonable.
Right. And so what the Actons are arguing is searching everybody is unreasonable.
Right.
Yeah,
exactly. And the court has historically been pretty antagonistic towards those kinds of like general searches. You have to have some pretty special needs. That's kind of the language that the court uses to talk about like when you can engage in searches outside of kind of the typical like, criminal context that we all know about where like you need a warrant based on probable cause. TLO said that in schools, because of the special needs of schools, you don't need a warrant and probable cause before you search a student, right? Because of the kind of the informal nature of school discipline and the need of schools to kind of engage in the care and tutelary obligations that they have towards students, we need a slightly lower standard, which is why TLO gave us, that 2 prongs.
Did you say tutelary?
I did say tutelary. Is that not a word?
Honestly, dude, I have never heard that word.
It's tutelary? A Scalia-ism. Yeah.
Tutelary.
Custodial and tutelary. Now you got me second guessing. I'm going to Google it. Tutelary.
Serving as a protector, guardian, or patron.
There you go. See?
Just like...
See, you learn something every day.
I know.
Shocking Gavel. Yeah. So because of the custodial and tutelary obligations of schools, the TLO court said that, school officials, when they've got suspicion of wrongdoing, can search students as long as that search is justified at its inception and reasonably related in scope.
Right.
Here, we don't have justified at its inception. So we've got to think through, how do the special needs here apply to this particular context? And so the court gives us a balancing test. And that balancing test is going to look at 4 factors.
Okay.
On one side, you've got the nature of the privacy interest and the level of intrusiveness into that privacy interest. So what's the interest at stake? And then how significantly does the search invade that interest? So
which is kind of similar to, aspects of TLO, right?
Very much so. Yeah. Right. Yeah. Because the second part of TLO looks at whether or not the search is reasonably related in scope. So you have to look at the intrusiveness and what property interests or privacy interests are being intruded upon, and compare that to the government's interest, which is the second set of factors here. Is you have to look at the government's interest. So the nature and significance of the government's concerns, as well as how well the search is going to further or address those interests. Okay. So those are kind of our 4 things. On one side, you've got the student and their interest and the level of intrusion. And on the other side, you've got the government's interest and how well the search or the intrusion into that interest advances the government's goals.
Okay. Gotcha.
So let's talk about it.
Okay.
So for the privacy interests at stake, this one is interesting because all of this is so contextual, right? Mm-hmm. Mm-hmm. The 4th Amendment protects individuals' reasonable expectations of privacy. And as we just talked about, reasonableness is going to depend on the context.
Yeah.
And so just because someone thinks something should be private doesn't necessarily mean that society or this objective person in society is willing to recognize that as being a reasonable expectation of privacy.
Right.
And particularly important in this context is we are at schools. Mm-hmm. And because schools have that custodial and tutelary authority over students, schools need to keep students safe. They need to keep them healthy. They need to ensure that it's a sound educational environment conducive to learning. Because of all of that, that implies a certain level of control over students that doesn't exist for, typical citizens out in the world.
Right.
There's a very particular context here.
Right.
And so because of that, courts have said that students have a lesser expectation of privacy in public schools. Mm-hmm. And that counts doubly for student athletes because, at least according to the court in 1995, student athletics are, quote, not for the bashful. That's the phrase from the court. And the court spends a significant portion of the opinion talking about the lack of privacy in student athletics. So you change in the locker rooms, you've got group showers, there's lots of limitations on your privacy. And all of that is done voluntarily as part of participating in student athletics. So students can choose whether or not to go to athletics. And, if you don't go to athletics, then you're not subjected to this kind of loss of privacy. And so the court essentially says, yes, there's a privacy interest at stake here, but that privacy interest is, the expectation of privacy is lessened
because you have a choice
of the nature of student athletics. Exactly.
Yeah. We're not forcing you into that group shower situation.
Right. Yeah. Exactly. Yeah.
Yeah.
So the next thing they have to think about is the level of intrusiveness of the drug testing. And this is our conversation about how icky or not this was.
Yes.
Right. And so, students obviously have privacy interests in their unclothed body.
Of course.
You have privacy interests in kind of your typical bathroom bodily functions.
Sure. Yep.
But again, the court here is pretty dismissive of those privacy interests. According to the court, because folks are using the public bathroom with others, which is something they do all the time, the privacy interests compromised by the process of collecting the sample are negligible. And, you know, we kind of already talked about why that may or may not be the case. And I don't necessarily think I agree with that, because I think there's probably much more significant considerations given kind of like the age and maturity of students and, you know, all of those other factors.
Sure.
But that's what the court said.
Right.
And the court went on to say that, you know, not only is it minimally intrusive collecting the sample, but there's minimal invasion of privacy in, you know, the anonymized
the
testing.
analytical aspect of
exactly, and then the limited reporting of information to just a very select few. So all of that kind of cuts against this search and kind of shows that like this search is not, according to the court, very intrusive. So you have a lesser expectation of privacy. This isn't a very invasive search. Now we got to balance that against the government's interest and how well the government's interest it is advanced by the search. And here we've already talked about this, like
safety.
Exactly.
Yeah.
Safety, the role model effect of student athletes, like they were at the head of the serpent of this drug culture, right? And so not only is it a very significant, the court says, if not compelling interest in, you know, reducing student drug use, but we've got a ton of evidence from the school that like this was a significant immediate concern that was having a profound effect on the school. And we've got evidence that this is specifically targeted to kind of the leaders of the drug culture who are also uniquely susceptible to the harms of illegal drug use. So all of that says that, yes, you've got a really important interest, and yes, this is sufficiently tailored to help you advance that interest, because you're just targeting the leaders and they're the people who choose to go into these sports. And if you don't want to do the drug test, then just don't play the sport.
So they just factored all of those things and put all that on the balancing scale, and it all tilted in whose favor? I mean, well, we kind of gave it away
right
at the top. Yes, you can test athletes. So the school won the balancing test.
The school won the balancing test, and the court said that the drug testing passed constitutional scrutiny. So it was a reasonable search under the Fourth Amendment. And so there are a couple other opinions in this case. So that's the majority opinion written by Justice Scalia. There were two other opinions. One was a concurring opinion from Justice Ginsburg, who basically expressed her understanding that the opinion was just about student athletes who voluntarily chose to participate. It didn't say anything about drug testing the general student body. For Justice Ginsburg, that would be a very, very different
it's a line. It's a line that she wouldn't want to cross.
That would have been my guess. But there's also a dissenting opinion, which I think is really, really interesting. So the dissenting justice was Justice O'Connor, joined by two other justices. And they are really concerned about this distinction between a blanket search and a search based on individualized suspicion. And for Justice O'Connor, she was looking at this and said, why are you doing this blanket search, which is invading everyone's rights, and that's a much greater threat to liberty? Why are you doing this blanket search when every example you gave, you could address through an individualized
to a person?
Right. Yeah. And so she would basically say, like, you know, the government does have an interest here. Yeah. But the way in which you're accomplishing this could be accomplished in less restrictive ways. And so we don't need to do this blanket search when we can just do individualized suspicion. And for her, she didn't think that the government or the school here had given enough of a substantial justification to justify that kind of blanket search in the absence of individualized suspicion.
Interesting.
And so, you know, it's a really interesting case, Vernonia is, because it is in a lot of ways a really profound judgment call about like balancing all of these different stakes against each other. And, you know, we talked about how the court was interpreting these things in different ways that, you know, maybe we would have thought differently. But the bottom line is, at least where you can show a significant, immediate concern, then schools, yes, you can do these kind of broad, general sweep searches in the absence of individualized suspicion, you know, as long as you've got that important governmental purpose, and it's not too intrusive. Given the protected property right.
And I do want to exactly. And I do want to say too, like that it's important to note that, you know, the government interest here doesn't just have to be safety, for example, right? Like that obvious, you know, that feels, when we're talking about this case, that feels like a really reasonable sort of government interest in this particular situation, because you don't want, you know, wrestlers or football players whose, you know, reaction times and ability to manage the physical demands of their sport. You don't want that stuff to be compromised because that could cause injury or whatever. But that's not the extent of what government interest could be. And we've had subsequent cases.
Yeah.
That have
because the Earls case, which
was
a Supreme Court case after this one, said that you could drug test anyone in extracurriculars.
Exactly. So even the chess club, right? Which is not full contact last time.
I have a lot of problems with Earls, the case, because it basically ignores all of the context of Vernonia. But you know, that's another episode, I guess.
That could be another episode. But yes. So anyway, it's definitely an interesting topic when we are dealing with, you know, things like the reasonableness standard and these complex kind of balancing tests. You know, you're throwing in a lot of nuance into a lot of different variables. Right.
And this comes up in way more context than just drug testing, right? This is
safety.
Anytime.
Yeah, like metal detectors.
Drug sniffing dogs. You know, lots of different situations where like a lot of different people are being subjected to searches or intrusions into their privacy.
And now AI, facial recognition, all that stuff that stuff is
social media sweepers that just like pull everyone's social media. Like, all of this stuff, like, you know, we're not looking for any one individual. So like, this is an even bigger challenge in the age of like big data, right?
Exactly.
Yeah. And we're going to cover some cases like that soon, because those are definitely coming down the pipe.
Yep, they absolutely are. It's it almost feels like some aspects of education law these days. It feels like Wild Westy, right? Like no, you know, there's no foundation, there's no framework for some of these things. We're just kind of making it up as we go along. You know, hopefully making it up in a systematic, you know, thoughtful kind of way, right? But, you know, we'll talk about it.
Technology, changing political tides, like, there's a lot going on.
There's a lot.
There it is.
There's a lot.
Yeah, we're not writing on blank paper, but we are answering a lot of new questions.
Exactly. All right. Well, there you go. Vernonia versus Acton from 1995. Chris, what is our homework?
Your homework is to go watch all of the movies we referenced in this episode.
So I think it's Ghostbusters,
Ghostbusters, Star Wars.
Yeah. Dazed and Confused.
Yeah.
Breakfast Club.
Yeah. Let's just add Ferris Bueller's Day Off for fun at that point.
There wasn't. Was there drug use in that one? I don't think there was.
But you know, we're talking about student rebellion, so you might as well. Yeah. It's a good movie.
Exactly.
Yeah.
Exactly.
And it seemed to fit the theme, apparently.
Well, yeah. And it was 80s and... But
go to chalkandgavel.com. We don't have any of those movies there. But we do have is merchandise. So you can get our merch. You can support the show. Your support means the absolute world to us. Like, rate, review, Chalk and Gavel. That's huge for getting us into the algorithms. Find us on social media. We'd love to hear from you and
there's a feedback form on the website. Fill that out. Let us know what you think of the show. Always trying to make it better. So, yeah. Cool. Okay. Well, there you go.
Time to go watch Spaceballs.
Have a good one, everybody, and we'll see you again in 2 weeks.